Hello and welcome to the first instalment of our seminar on employee use of social media, brought to you by Howard Avram Solicitors. Today we are focusing on the hot topic of employee misuse of internet and emails. Whether you are an HR professional or small business owner, the use of internet and emails by your employees can be a real headache, and knowing what your responsibilities are is important to avoid getting into a legal quagmire. Social media is now part of everyday life. It's the new normal, and with nearly 2 billion Facebook users globally, it's not going anywhere. However, it can have pitfalls in the work environment, and legal cases frequently occur. If I can start with a basic piece of advice, don't ignore the importance of social media in the workplace. Undoubtedly, employers who have in place appropriate policies and contractual wording will be better placed to protect the business than those who have not. The cases that have occurred to date and been resolved at court level are now defining what you should and shouldn't do as an employer. We're going to look at these real-life cases and provide you some checklists for action within your own workplace. As I said, this is the first instalment in 4 chapters on this topic. When we finish this short seminar, make sure you move on to view the rest. So on today's topic of misuse of internet and emails, we're going to zoom in on 5 examples where it can go wrong if you don't have a clear policy in place. First, excessive internet use. Second, inappropriate emails. Third, sharing pornography in the workplace. Fourth, when someone downloads unauthorized software. And fifth, an employee's right to privacy. With the first example, excessive internet use, it is critical that you communicate the standards of conduct expected from employees. This means creating a policy on email and internet use and distributing it. Do not leave anything to chance. When you create this policy, make it clear. A case against Meaty Property Services in 2009, from when 2 sisters were dismissed following excessive internet use, was lost by the employer because their policy was deemed unclear. Where the employer has no policy, the tribunal may take a common sense approach which may not be favourable to the business. For example, a tribunal deemed it excessive for an employee to spend 10 to 15% of work time surfing the web. I should think so. After all, you are paying them for this time. With the second example of inappropriate emails, our real-life example is from when an employee was dismissed for sending saucy emails to a client from her personal email. The courts determined that because the business then lost their client, the dismissal was deemed fair. However, in our examples where an employee has been dismissed for sharing pornography, their dismissal was deemed unfair. This is because the employer had either neglected to share their policy that categorised levels of offensiveness, or, as in the second case, the employer had failed to consider a medical influence. In our fourth example, a case against Dundee Cold Stores, where the employee was dismissed for downloading unauthorised software, the dismissal was held to be fair as ample investigation into his conduct and the employee's past disciplinary record was carried out by the employer. It shows how important it is to investigate deeply and look into someone's disciplinary record, circumstances, and the company policy in place. Finally, in our fifth example, to illustrate the importance of an individual's right to privacy, we're going to look through a case study. As background, GoGo Games Limited is a games retailer with over 300 stores across the UK. Their employee Marco opened a personal Twitter account without using the restriction settings, so his tweets were publicly visible. A manager raised concerns about allegedly offensive and abusive tweets that Marco was posting. Ultimately, Marco was dismissed for gross misconduct and he brought a claim for unfair dismissal. So, what was the outcome? Well, the tribunal needed to assess the balance between an employee's desire to reduce reputational risk from social media and an employee's right of freedom of expression. They decided the dismissal was unfair. This is because the tweets were posted for private use. It was never established that members of the public or employees of GoGo had access to tweets or associated Marco with GoGo. And finally, there was no social media policy shared with the employees. So what can we learn from all this? Here's our checklist to help avoid the legal pitfalls of misuse of internet and emails by employees. Do have a clear policy on IT and communication systems in place. Do specify to what extent employees can access social media sites. Make it clear that employees should not disparage customers, suppliers, or employees online in any way. Confirm that the employer reserves the right to monitor employees' use of email and internet. Apply your policy consistently and fairly across the workplace. Investigate, 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 and assess damage to the business. Do not apply a blanket ban or respond with knee-jerk reactions should any issues occur. To close off, here's a reminder of how social media is the new normal. You can see some huge numbers there in terms of uses every minute of every day. Your staff, your boss, your friends and family are all involved. There are new apps and uses every day. It is not going away. Thank you so much for your time today. We hope this has provided a useful introduction to the topic of employee misuse of internet and emails. How at Avram focus on law for businesses, and our clients appreciate our straightforward, practical and commercial approach. We enjoy providing tips and advice for businesses that will help keep them healthy and dispute-free. Don't forget to watch our other seminars in the series, and do feel free to get in touch if your business is in need of any legal advice.